people from using the courts. Can you tell people what the Supreme Court did just a few weeks ago?
Yes. I mean, there's one sort of bright light here in that the United States Supreme Court a couple of weeks ago put a hold on a court decision out of the Eighth Circuit in a case challenging discriminatory voting lines in indigenous communities. The case was known as the Turtle Mountain case. And it followed a case a North Dakota case that followed a case in Arkansas that also was arguing that the redistricting maps were racially retrogressive. And in both of those cases, the Eighth Circuit concluded that the voters whose right to one person, one vote and right to fair representation was violated by these gerrymandered districts. And in the Turtle Mountain case, the court said, in addition, the Civil Rights Act could not be used. So you have a situation here where the Eighth Circuit says voters and the organizations that represent them have no ability to challenge discriminatory voting laws under Section 2 of the Voting Rights Act. And so in the Turtle Mountain case, they said, okay, we're also going to add the Civil Rights Act, which directly allows individuals to sue for violations of their civil rights. And the Turtle Mountain case said, no, you can't even sue for your civil rights under the Civil Rights Act. And it seems that perhaps that went just a little bit too far. And that's the provision that the United States Supreme Court put on hold. But just yesterday, the Eighth Circuit issued another decision saying that a different provision of the Voting Rights Act, Section 208, which ensures that it says every voter has a right to assistance by a person of their choice. And there's a case in Arkansas and a case that Missouri Voter Protection Coalition is litigating out of Missouri as well under this provision that limits voters' access to assistance. Even there, the court said, despite this clear language that every voter has a right to assistance, they said that voters themselves can't sue for that right. And that there's no standing under this section of the Voting Rights Act as well. So this is a very disturbing trend, and it's one that we're seeing over and over where courts are finding that aggrieved populations lack standing to challenge the deprivation of their civil rights. And this just flies in the face of what the Voting Rights Act was intended to do. The courts in all these cases say, well, Congress needed to explicitly say that voters have a right to access their rights under the Voting Rights Act. And because that exact language isn't in there, that the only one person in the entire country can actually bring claims under the Voting Rights Act, and that is the Attorney General of the United States. That violations of the Voting Rights Act are violations against the nation, and that voters themselves cannot. The courthouse doors are closed to them. And now, after yesterday's decision in the Eighth Circuit, we're seeing that even their right to assistance is going to be closed off to them. Now, that case could get appealed. We could ask the Eighth Circuit entire bench to reconsider that decision. But this trend is going in the wrong direction. And what we're seeing time and again are decisions that close the courthouse doors to voters to be able to assert their rights, but at the same time give extensive additional powers to political decision makers to act without accountability to the law. And that's what's happening here. Our case in Missouri challenging Missouri's restrictions on assistance, we filed that back in 2022, and not a single thing has happened in that case because it's been on hold waiting for the Eighth Circuit case in Arkansas. And now it appears that voters' rights will remain elusive. The Missouri law issue is even more strict than the Arkansas law issue, which, by the way, was blocked by the lower court. They found it clearly violated Section 208 of the Voting Rights Act. Missouri's law says every voter has a right to assistance by a person of their choice, but a person providing that help can only help one person in an entire election. Right? So more organizations, civic engagement organizations that provide disability assistance and language assistance, which is really critical in a place like Missouri because they're not required to provide voting materials in multiple languages or have translators available. It's simply impossible.
One thing, Denise, I mean, let's go back a little bit because I want people to really, 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 really understand what this means. If you can't bring a private right of action, and the only entity that can do so, if there is no private right of action to bring a lawsuit, and the only entity that can do so is the Justice Department, Daryl, come on, Daryl, what does that mean? You were telling the people earlier today about who brings these cases. What would this mean?
Yeah, no, you're absolutely right, Barbara. So if you're a person with a disability, or you need someone to help you use the voting machines that are there because they decide they want to have it all super tech, and you're not a techie, and you just need somebody to help you, the only person that would be able to bring a violation, bring a cause of action, file suit on your behalf to say you're depriving me of my right to go in and vote by myself, would be the Attorney General of the United States, right, Pam Bondi, as well as the Department of Justice. They are the ones that would be able to file that. The part that makes it really interesting is that we know that they've gone through a 70% cut in staff to the Civil Rights Division there for the people that would actually litigate these cases. So, and we also know that 90% of the cases that are filed dealing with violations of the Voting Rights Act usually come from private actions, from private causes of action, not from the Office of the Attorney General, not from the Civil Rights Division, not from the Department of Justice. So, it's really just, and Denise, correct me if I'm wrong, but you're really just gaslighting the violation of people's access to being able to vote, and for states and localities to be able to discriminate however they want against people with regards to their voting rights. Am I wrong on that, Denise?
You're absolutely right. I mean, I couldn't have said it better. It is gaslighting. And on top of that, if you foreclose the ability of people to go to court to assert their own rights, what incentive does Pam Bondi have to bring any case at all under the Voting Rights Act, right? It forecloses not just people's ability to assert their rights, but it forecloses any accountability, right? Because now the Justice Department doesn't bring the case. And as you correctly mentioned, 90% of the cases brought under the Voting Rights Act are brought by voters and their advocates. Because those are the people who know how the laws are affecting them and whether they are being implemented in a racially discriminatory manner, as many of these district lines and redistricting cases showed. And so then you have these.
I'm
I
sorry.
was going to say, when you look at that in combination with the Supreme Court's emergency ruling in the Casa case, Casa v. Trump, saying that the courts also have the ability to issue broad injunctions, which is what the Voting Rights Act does. So now people can't assert their rights because apparently the only remedy is a broad injunction. That's kind of the reasoning of these cases, is you can't issue a ruling saying this law is unconstitutional, but only for you, plaintiff A. And that's one of the reasons the court's saying that there's no private right of action. because the only remedy is an injunction. And now the courts are saying, they also can't issue broad injunctions to laws that are facially unconstitutional or facially violate the Voting Rights Act.
Right. And everybody, an injunction is basically a stop order. It says you got to stop this. You can't do this anymore. So when we use the term injunction, we're talking about when the court tells a governmental entity or tells an election official that, no, you can't do what you're doing because it violates the law. It's racially discriminatory. And it's not just in redistricting, because tell us about your news case. I mean, come on, it is every aspect of voting that is affected by the Voting Rights Act, Section 2.
Well, and it's just turning the judicial branch on its head, right? It is doing the exact opposite of what it's been intended to do. And it's trickling down into state litigation as well. I mean, what these cases have done for someone like me, as a voting rights lawyer who's in the Eighth Circuit, we no longer bring federal cases. The one that we have has been sitting for years. And so we're bringing cases now under our state constitution. And we just filed a brief a few days ago to the Missouri Supreme Court challenging discriminatory photo ID requirements to vote, which we know, and there's tons of data showing that they disparately impact communities of color, low-wage workers, seniors, people with disabilities. And they are the lower court said that the NAACP and the League of Women Voters didn't have standing to challenge these laws on behalf of their members. And the state is now arguing that the court has no power to rule this law unconstitutional and issue a facial injunction, even though it is clearly unconstitutional on its face under our more protective Constitution. And so that is the remedy. When a law violates the Constitution, it cannot be implemented. And it's not that you can't have a situation where a law that violates the Constitution is allowed to be implemented somewhere and not allowed to be implemented as to other people. And, we are really seeing an entire reimagining of the courts, where the courts lack the power to hold the other branches accountable. And that's really dangerous. The Missouri legislature this year passed a law known as Senate Bill 22 that actually said the courts don't have any power to remedy summary language on a ballot initiative that it has found violate Missouri's law against being deceptive or misleading. And so when you take away the power of one of those three branches, as we've seen happening both at the federal level and at the state level, you now have a very wobbly stool, and one where political branches control the other branches, and that is not how our democracy was founded. You know that things are getting crazy when you have opportunity to cite to Marbury versus Madison in a brief, okay?
And that's one of the first major Supreme Court cases, yes.
Right, back in 1802.
Yes, and audience, we know that most of you aren't lawyers, and we are just trying to make sure that you understand the danger of this case, the danger of these cases, the danger of saying there's no private right of action. If there's no private right of action, everybody, we want you to understand that the VRA is a nullity. It doesn't exist for all practical purposes to help people who are facing discrimination in voting. We just celebrated Good Trouble John Lewis, who was beaten on that Edmund Pettus Bridge 60 years ago for his, fighting for voting rights. And because of what happened on Bloody Sunday, the Voting Rights Act of 1965 was passed eventually that year. And in fact, on August 6th, we're going to have a national teletown hall in honor of the 60th anniversary of the Voting Rights Act. You heard us. You can go to tjcoalition.org, and you're going to see our flyer. You're going to see information about that upcoming teletown hall. But I want you